Justice of the Appellate Division Court Department, hear ye, hear ye, hear ye. All persons having business before this court will draw here for their defendants and so here.
Thank you. Please be seated. The first case on for argument today is case 749, People v. Wiggins.
Good morning.
Counsel, good morning. Mr. Stahowski, can you hear us?
I can very loudly.
And we can hear you also. Counsel Healy, can you hear us also?
I can, Judge. Thank you.
Very good. Thank you. Counsel, please proceed.
Okay, good morning, Your Honor. This is the case of Jalen Wiggins, which in my opinion is filled with egregious errors from the very onset. And when we look at the factual background, we see that the trial went forth and that witnesses never identified Jalen Wiggins. They identified clothing, they identified white pants, and they identified a Burberry shirt. Not one witness came forth and identified Jalen Wiggins.
Well, Mr. Stahowski, I think at some point there was a witness, pre-trial, who identified the defendant, but then at the trial was unable to or unwilling to. Is that correct?
Your Honor, at the trial, I believe that's the witness that said on cross-examination that he had learned about it through rumors in the street, and that's not really an eyewitness. He learned that in the street that Jalen Wiggins was the shooter. That's a major problem with the case itself, that there's no clear identification for the jury to make a conclusion that one, there was a shooting, and number two, that Jalen Wiggins was the shooter. Okay, so the jurors are the major issue in this case, in my eyes, because in this case we have jurors that were racially biased against Black people. The one person said all Black people look alike in the dark. That is outrageous. It's 2023. In 1956, I think people said that, but in 2023, and I think this was 2021, that's just clearly someone who's set forth bias, not only implicit but explicit bias, and
This was brought when this was brought to the court's attention. Did the court address it, Mr. Stahowski?
Actually, they addressed it, but did nothing about it. The defense counsel asked for a mistrial, and the person, when they were interviewed, said that there were 6 people back in the jury that were of the same opinion, and in that kind of a situation, it's abhorring. And the judge did not call any other jurors out to see if they shared this biased opinion.
So you're saying the trial judge had an obligation to do more than the trial judge did in this case, to investigate and determine whether or not the jury was infected in some fashion.
Absolutely, because if one says that Blacks are different, we live in a whole different culture than white people, that all Blacks look alike in the dark, That's why they couldn't identify his face, only his clothing.
You also make an argument that one of the jurors was asleep during a critical part of the trial, right? The jury
Yes,
charge.
there was a juror that was asleep during the jury charge, and he claims, I wasn't asleep. I just nodded off, but I wasn't sleeping. Well, nodding off to me is sleeping. I mean, I don't know of anyone that's ever said I nodded off that meant that they were awake and listening.
We'll take, you've raised a number of jury issues, and you've already addressed your first point. Is there anything further?
No, Your Honor. I think my brief is very comprehensive, and I'll leave it to Your Honors to make a decision.
Thank you, Counsel. Counsel Healy?
Thank you, Your Honors. May it please the court, Harmony Healy on behalf of the people of the state of New York. Mr. Sahowski raised a number of issues with respect to identification and the alleged racial bias in the jury. Your Honor, Judge Bannister, you are correct. There was originally an identification. This individual did this based upon information that he had received from people outside of the trial that the defendant had been shooting up people that night. And so he independently went to an application called Mobile Patrol and found the defendant's picture and called the detective in charge and said, I have been able to identify this person. And then he did the photo array that was police identified and arranged. He was fully cross-examined on the recantation. He did recant at trial, but I think there was a sufficient amount of testimony at trial that witnesses were not forthcoming because they had been threatened in the presence of the court, but outside the presence of the jury. One of the attorneys that was representing a material witness that was incarcerated because he was too scared to testify said that there was a $40,000 bounty on his head. So I think that they could weigh the information that they received, and they were in the best position to evaluate the credibility of these.
I have a question for you. Okay, so the comment that is undisputed, okay, that was made that all black people look the same at night. In the context of this being a identification case, is there any way to view that comment as being not the product of bias?
Yes. So, and this was, the court did actually, after receiving that note from juror number 5, did call in the second juror that was alleged to have made that comment. And the juror that was called in when she was explaining the comment that was made said, I didn't mean that to mean that all black people look alike or that I'm racially discriminating against anyone. What I meant is that it is very hard to see on the video because the video is in the dark. And so the white pants in the video stand out and the yellow colored shirt in the video stand out, but it's hard to determine any features because it kind of blends in because the night was so dark on that night. So
didn't she also say, I'm sorry to cut you off, but didn't she also say that she had an Asian daughter? Well, would there be a need to say that she had an Asian daughter versus just a daughter if race were not an issue amongst the jurors?
So I think that what she was trying to say is that I don't have a racial bias. I don't put other people, and I can evidence that by the fact that I do have a biracial daughter. I obviously don't take race as an issue, but because of the darkness of the video, she also said that that wasn't exactly what she said, and that wasn't how she said it. And she indicated that she would hate for somebody to be falsely convicted on something just simply based upon their race or something like that. So she explained it to say that she wasn't using that to mean that this defendant was guilty because of his race. And she made that absolutely clear when she was questioned. She denied any racial bias whatsoever, and the court and the people.
Did the trial judge have an obligation to inquire further of the other jurors that were alleged to have been engaging in this racial conversation?
I think that the trial judge has a good amount of discretion over a kind of issue like that, and I think that the case law kind of goes back and forth and says if you call every single juror in under that context, then you're sort of making you open yourself up to a possibility that there are going to be more issues by calling each and every single person. So you're just sort of creating an open problem within the jury instead of just getting an answer on the record explained by the person who was alleged to have made the comment. And when the person was alleged to have made the comment explained further, it was clear that she didn't mean it in the way that it was being taken. And actually she said she hadn't said it in the way that it was being taken.
But wouldn't, if it's an allegation that it's 6 jurors that make this comment, wouldn't fundamental fairness require at least some further inquiry of those other people to ensure that the trial jurors were fair?
Well, so I think that the other part of this dispute was that they then called the juror back in, juror number 5, who was alleging this conduct, and juror number 5 said that everyone talked about it and it was sort of taken the wrong way and everyone was going forward, moving fairly. And so I think that it was sufficient in the court's mind, using his discretion, to determine that any such issue was quashed, and it sort of resorted back to their sworn oaths that they had taken to be fair and unbiased.
Anything further, counsel?
No, if you have no further questions, I'll rest on my brief.
Thank you.
Thank you.
Case 751, People versus Scott. Proceed, counsel.
May it please the court, Nicholas Stefanzo from Marquis Scott. Today I'd like to address points 1, 3, and 5 of my brief. Mr. Scott pleaded guilty under the false belief that the potential maximum sentence he faced was 45 years, which was 25 years.
That was by operation of law, right, Mr. Stefanzo? It was like the court got the maximum term wrong. It just didn't give complete and accurate information that it would have, by operation of law, been reduced to 20, correct?
Correct. The administrative maximum is 20 years in his case.
And you cite the People versus Joseph case from the First Department, I think, having to do with preservation, right, among other things.
Among other things,
Doesn't
yes.
our court typically, in these situations, require preservation in the form of a motion to withdraw the plea, which probably isn't realistic here, but at least a motion for post-conviction relief under 44010. Our court pretty routinely, I think even in situations close to this, say that it has to be preserved. And do you agree that generally speaking, that is the rule?
Generally speaking, I think I did say that in my brief, but the argument is that the defendant is under no obligation to preserve an issue that he doesn't have any knowledge about.
Why not? If you can raise it on appeal for the first time, why can't you bring a 440.10 before the judge who took the plea knows all the discussions of it, knows the background? I mean, there were clearly discussions off the record that are referred to here in the transcript. Why shouldn't the defendant, given our case law, be required to go back to that judge and say, hey, judge, you misstated it. You didn't get it quite right. You told me 45. It's really 20. I want to take back my plea, vacate my conviction. Why shouldn't that be the rule under these circumstances, to go back to the sentencing judge?
Well, I think just generally the preservation rule implies that there's some sort of knowledge on the part of the defense counsel or the defendant that something could have been objected to, that something is there to object to. But there's no record here that anyone caught the error. The prosecution stated it and the court repeated it and no one corrected them. And so it's kind of speculative to say that he was aware of the administrative maximum.
I'm sorry, but either way, I mean, originally he had a pretty good plea. He was facing, each one of those counts, 15 years.
Yeah, I agree that
he had no reason
6 to 8 year term,
Right.
is certainly quite less than 20 years.
Right.
So, but
This is coming up afterwards because the judge enhanced the sentence.
possibly not.
But why not bring it back to the same judge? What's the problem with bringing it back to the same judge?
I don't think there's a problem. I'm not sure I follow, Your Honor. I don't think that I argued that it shouldn't go back to the same judge. I'm just saying here that the plea itself is involuntary because the course of pressure of a prosecution is determined by the potential maximum. And 45 years is an order of magnitude more of pressure.
In this
20
particular
years.
case, we even had a situation where the defendant, in the interview with the probation department, referenced the fact that the 45 years was weighing on him for purposes of the plea. Getting back to the question of going back to the original judge, you're not in other words, maybe you had a remedy to go back to the original judge on a 440. But your argument here is it wasn't a knowing, voluntarily intelligent plea. And if the preservation rules allow it to be brought here, maybe you had both options available to you, and you're raising the option now before us.
Yes, that would be my argument.
And Counselor, my concern on this, among others, is, and I could see an argument, to be honest, both ways. It should be preserved or should not have to be preserved. But if we go with you on this one on lack of preservation, it seems like any time the court misstates the maximum sentence, that in and of itself never has to be preserved. That's basically the rule that you need us to adopt here in order to agree with your preservation argument, correct?
I wouldn't say so, Your Honor. I think
Give me an example, if you can, off the top of your head, because
Sure.
I can't find one. I've given it some thought
Well,
as to.
I think the rule, the rubric here is the totality of the circumstances. So everything, this court considers everything that happened, right? And in this case, you have an enormous gap between the actual maximum and the potential maximum that was
Look at the
stated.
totality of the circumstances, like shifting to the merits. See, there, that becomes a facts and circumstances test. And that would almost suggest that the court really needs to hold a hearing upon a motion of some sort. But putting that aside, if you look at the merits, taking that second part, here, the nature, the Garcia case says, the nature and the terms of the agreement. 6 to 8 for 3 separate burglaries where each place was ransacked. Not just burglaries, but ransacked. 6 to 8 is a darn good deal, wouldn't you agree?
Yes.
Okay. So in the Garcia factors, the nature and terms of the agreement means we shouldn't set it aside. So the reasonableness of the bargain, you would say it's reasonable. And this was not the first situation where your client encountered the legal system in this context, correct?
Correct.
So if we consider his age and experience, that doesn't cut favorably to reaching the merits, does it?
I think it does when you look closer at his age and experience, when you consider the cognitive factors going on with his client.
Thank you.
With just with respect to the preservation argument, I just think that the rule adopted by the First Department applies, that there's no requirement to raise an argument that you aren't aware of. If this court does determine that...
Would this qualify for our interest of justice review discretion?
I think it would, and also, yes, I clearly think it would, and it was also, I would argue, Your Honor, I honestly hadn't considered this, but I would say that it's ineffective. If there was a requirement to preserve this issue, it would be ineffective on counsel not to have raised it beforehand. With respect to the enhanced sentence, that argument is very simple. It's simply that the enhancement was not supported by the record. And that's because the condition itself was that the defendant answer the questions put by the probation department truthfully.
And your argument is that there needed to be something more done by the judge at the time to determine whether or not it was truthful or not. The judge simply offering to bring the probation officer in wasn't enough, even though it was offered, I think, twice, and declined, and only asked once the sentence was enhanced. So your argument is more needed to be done. It wasn't clear that it was truthful or not. The trial judge in this case, though, made a point, I think, of saying there's very little room for a disagreement over what was said. For the defendant to say here, it's a misunderstanding, the judge is saying, I don't see how you can interpret this as a misunderstanding. And
I think what it goes down to
how would you address that?
I would address that by looking to the actual condition that the judge stated at the time of the plea, which was to be truthful with respect to the questions put to you by the probation department. And since there's no record of what questions those were, it's impossible to say whether or not he was truthful with respect to them. It is possible to make statements that contradict your plea allocution that are nevertheless truthful with respect to certain questions. You simply don't know if that happened here because you don't know what the questions were.
He told him that he didn't commit the burglars.
Yes, that's
Which
correct.
is-
We have other cases, I think I cited.
Which is exactly what the judge put to him. He said, did you tell parole that you didn't commit these burglaries? And that's when he walked him back.
Well, the judge never found out what parole asked him. So if parole had asked him some questions similar to, for instance, the People versus Becker case.
This was a probation interview, right?
Yes.
Yeah, yeah,
The
okay.
PSI, yeah. So
Yeah.
if they had said, well, tell me what happened in your own words, or something like that, or what's your impression of what happened? Well, then he has, free reign really to give them what his truth is, what he understands is the fact of the matter of the situation. And just, so the argument is just without the questions, there's no way to know whether or not the enhancement is lawful. And finally, I would just want to make two notes on the harsh and excessive argument. And the first is that this conviction, these convictions, the underlying offenses actually predated another conviction for burglary for which he was granted youthful offender status. And our argument here is that that is just incoherent. The sentence is incoherent with him having been granted the fresh start of youthful offender status. And secondly, our argument is that doubling the sentence, giving an additional 6 to 8 years for a purported denial of responsibility that was at most temporary since he recanted that sentencing, is disproportionate on its face.
We'll take a look at that, counsel. Thank you.
Thank you.
May it please the court, Michael Hillary for the people. I'll start with the first point unless the court would like me to go elsewhere.
That's fine.
I'll focus on the totality of the circumstances. Justice Curran, you stole my thunder there. There are a number of factors besides. Yes.
Hang on one second, though. I don't want you to have the wrong impression. I'm not sure where I'm going on this, to be honest. But the other thing is, when it's so, does it matter when it's so bad? That is it like an elastic test? That is, when it's 45, you're saying you can get 45 and it can never be more than 20. Does it matter that the misstatement of the max sentence is so wrong? Or does that not matter? That is, the misstatement is all that really matters? Or do we have to consider the extent by which it was misstated?
And let me just start, Judge, if I may. I didn't mean to be presumptuous, only that you synopsized my point better than I think I could here. But as to Your Honor's question, I would say at least the Joseph case suggests that much. That's a fair point, 45 years. And then it outlines a number of circumstances which I attempted to distinguish from those in our case. So, for example,
Trial.
on the brink of trial, just before trial, being repeatedly told you face 45 years, repeatedly. Here, there was a period of time of discussion with counsel in chambers. There was no trial date yet in the offing. There wasn't any of the kind of pressure that attended Joseph in those circumstances here. So for that reason, I think they're distinguishable. And then
Counsel,
once,
let me ask you this, with
Yeah.
respect to plea offers, right? And that's what was going on here. There was a conversation about this, and we had the judge, I think similar to Joseph, referencing the 45 years multiple times, right?
That's true, Your Honor.
And so, isn't there some pressure on defendants in that circumstance if they turn down a plea, that the plea may be offered, may be withdrawn, or may not be available after that date? I mean, that's always the case, isn't it?
that's a very fair point, Your Honor. There always is some pressure, and I don't mean to suggest otherwise, only that in Joseph, the pressure was exceedingly great compared to what it was here. And the pressure in this case was sufficiently low, I think, to allow the court more latitude and flexibility to look at the other factors and circumstances that were in play here. So example would be the age and the experience of the defendant. Now, The defendant was, I believe, 23 years old, if memory serves. The court has the record on that.
And this, does it matter, I think, in this particular case, that the actual crimes, it was kind of a cold case situation, right? The crimes had taken place a number of years before, right?
Yeah, there was some distance between the crimes and where we were with the plea, certainly.
There's some indication in the record that he had dependency issues from between the time of the crimes and the time of the plea.
That's true.
Yeah.
That's true, Your Honor. But when you look at all the factors, his young age notwithstanding, he was a veteran of the criminal justice system already. In 2011, he was adjudicated a person in need of supervision. 2012, he's convicted of harassment, trespass, false personation. I'm forgetting one other crime there. And then in 2014, he's convicted of attempted robbery in a third degree, for which he's adjudicated a youthful offender. And then subsequent to that, he's convicted of disorderly conduct. So he's been around the block. He's got some familiarity with how the system works. You add to that this was an extremely favorable bargain, as the court has already indicated it was, and the fact that it is a bargain for agreement, and that these bargains and pleas are supposed to represent generally the end of litigation and not the beginning of litigation. I think taking all those into account, this should be upheld.
My question is, why should the defendant have to preserve something that at the time of sentencing, he would have no idea that there was such an error about the 45 versus the 20? Why should he have to preserve it?
And Judge, the way that I went about my brief, I supported that view. There's First Department authority to that effect. So I didn't argue that, only went to the merits on it. I think that's a fair point. From where I sit, Your Honor, it seems as though a defendant really can't be held to argue a point when he just wasn't in a position to know. You've got the court repeatedly telling him, you've got counsel repeatedly telling him, the prosecutor affirming all that. So I went to the merits on it and intended to distinguish it from Joseph.
Do you want to address the enhanced?
Yeah, yes, Your Honor. Just for a moment, if I may. An obligation that he had was, besides just remaining arrest-free, was to speak truthfully to the probation department. He didn't do that. That's the presumption from what the probation officer relayed in the report, was that he contradicted. Not in the case of Becker, simply gave a different rendition of the facts. He outright contradicted his plea allocution here. He denied having committed the burglaries and then went on to talk about DNA and how DNA is...
And the trial judge made the point of saying this, there's very little room for misunderstanding here.
Exactly, exactly. So I think on that basis, it's a different situation than Becker, and, the enhancement was justified.
Anything further?
No, thank you, Judge.
Thank you, counsel.
Thank you.
Case 752, People versus Phillips.
Good morning, Your Honor. Scott Miles for the People. I see the appellant has submitted on this case. Unless the court has any questions, I will rest on my brief.
Very good. Thank you, counsel. Case 755, in the matter of Eric D.B. Counsel, Mr. Otis, can you hear us?
Yes, Your Honor.
Very good. We can hear you. Mr. Werner, can you hear us?
Yes, I can, Your Honor. Thank you.
Thank you. Okay, counsel, proceed.
Michael Werner on behalf of the department. I do see that the appellant has submitted. My opinion is that this is a pretty straightforward termination. I don't really see any issues. Unless there's any questions, I'll rest.
Very good. Thank you, counsel. Mr. Otis?
Thank you, Your Honors. Again, the appellant submitted. I'm not going to get into the merits, but I will briefly inform the court as to how these young boys are doing They are happy and playful young men in love with the family who has raised them entirely. They do continue to require some specialized medical care due to their severe growth deficiencies for one of them and some other issues. The family's now getting help from the Office of People with Developmental Disabilities to help process the children through their serious needs. They're getting help from special education. The older boy is now able to attend a full day of school successfully, where he works through his processing and sensory deficits, his diminished stature, etc. Most importantly, I think, and from a dispositional standpoint, I think these boys were kind of hit with the foster parent lottery jackpot. These are extremely devoted and loving folks. This home is pre-adoptive. They've been with the same family since the very beginning, and I would ask this court to affirm the lower court's decision in its entirety. Thank you.
Counsel, thank you for the update. Thank you, counsel.
Thank you.
Case 756, Ross versus Village of Fayetteville.
Good morning, Your Honors. John Tantillo for Petitioner Appellant Marguerite Ross. May it please the Court. We're asking the Court today to annul the decision of the Village DBA for primarily two reasons. First, the Court should annul the decision because it was a question of pure legal interpretation, and the ZBA therefore should have been afforded no deference by the trial court, as pure legal questions are ultimately questions for the Court. Then once the Court determines that it is a legal question, that decision was made, the decision that was made should be annulled as nonsensical, as it would lead to absurd results. The trial court erred by affording deference to the ZBA when it cited to the general rule that ZBAs are entitled to deference in interpreting their codes because it declined to discuss the qualification of that rule.
Counselor, specifically, can you identify for me the pure legal question that you think they decided specifically as best you can?
Yes, and that's actually right at page 77 of the record. The planning board very explicitly stated the question that it was posing to the ZBA, and it states, I can read it for you, it's said application requests an interpretation of this village code, section 187.14a, which provides that legal non-conforming structures may continue to be used, repaired, and maintained. The terms used, repaired, and maintained are not defined in the village code. Additionally, 187.14 is silent with respect to either allowing or prohibiting alterations, renovations, redevelopment, or a reduction in size of a non-conforming structure that results in a smaller structure that nonetheless continues under the village code to be non-conforming with respect to its size. That's the question they posed. They didn't say, can this 120,000 square foot structure be demolished here and expanded here? There's no fact-specific analysis in this appeal. It's a pure...
What draws my attention, Mr. Tantillo, on that is in that very specific question is built in, not defined by the code, and the code is silent. In that circumstances, isn't that the classic situation where the courts defer to a legislature?
Yes, and the court should defer to the legislature here when it said in its zoning chart that buildings in the village of Fayetteville cannot exceed 10,000 square feet. The applicant, in attempting to deviate from that zoning chart, is the party that needs to provide something in the code that allows them to, and nothing in the code does. As the Court of Appeals held in Raritan Development Corp., when the question is one of pure statutory construction, no deference is given. All respondents cite to this Court's decision in Clear, but that case is highly distinguishable. There, the decision turned on, quote, whether there was substantial evidence that the property was used for recreational activities and as a campsite. It's nothing like the question posed to the ZBA here, which is just the language of the code. So once we get to the fact that this is a legal question, we then argue that it was determined incorrectly. This is not a situation where a property has a 100,000 square foot structure and the owner wants to demolish a wing of that structure. In that case, all they would need is a demolition permit. The code is obviously silent on decreasing the size of non-conforming structures because decreasing the size of non-conforming structures, as anyone would interpret it, demolishing part of a non-conforming structure, doesn't need any village approvals beyond the demolition permit. Here, they're demolishing the structure, then they're building a new one. They're building a 56,000 square foot structure in a zoning code that limits structures to 10,000 square feet. And what the ZBA said in its decision effectively is, if you've got a non-conforming structure, you can build a new non-conforming structure, and that's not in the code. This is the absolute definition of form over substance, and it cannot have been the intent of the zoning code. Instead, the code should be read just as every other code in every other municipality in the state, in a way that does not allow for new deviation from the zoning code without a variance, which is exactly what they were seeking before they withdrew their application and tried to proceed under what I think everyone would fairly realize is an attempted loophole here. But they're still seeking site plan approval. They're still seeking a building permit. It's only with regard to the variance that they're pretending they're not building something new. So we'd submit that this interpretation is clear legal error and ask that it be annulled.
We'll take a look at that.
And then the second argument, in the event the court determines that it's not a legal question and that it is a fact-specific analysis in a specific project, there is not substantial evidence in the record to support the ZBA's decision. Now, substantial evidence doesn't just mean a voluminous record. If that was the case, then in every Article 78 proceeding I file, the respondents could just point to the administrative record and say, oh, the application is 1,000 pages long. Obviously, there's substantial evidence. Decision stands. But that's not the standard. This court defines substantial evidence in clear as where, quote, reasonable minds could adequately accept the conclusion or ultimate fact based on the relevant proof. And here, that's utterly impossible with what was presented to the board, because the applicants have continually refused to say what portion, if any, they're preserving. At various points, they've claimed that they're keeping the walls. Other times, they've said that keeping the walls isn't necessary. The application says that the building will have new walls, a new roof, and new floors. The code enforcement officer himself said, quote, the facts are yet to come out on the structure and, what part of the structure you're actually using. If the parties are entirely in the dark on what parts, if any, of the existing structure are being used, how can there possibly be substantial evidence to support a determination that this project is a permissible downsizing of that structure? And for these reasons, we've asked the court to annul the ZBA decision.
Thank you, counsel.
Thank you.
Good morning. May it please the court, I'm Brad Hunt from McKinsey Hughes on behalf of the Village of Fayetteville respondents. I think it's interesting that Appellant's counsel noted that this code should be, in their opinion, interpreted the same as every other code in the state. Because I think it's important to understand here that if you look at the particular language of the Village of Fayetteville zoning code, it is actually unusually favorable to the use of non-conforming structures, and it's different from many zoning codes in the state, and that's true in a couple different ways. First of all, whereas many codes, kind of along the lines that Mr. Tantillo was describing, will say, okay, if you got a grandfathered structure of use, you can have it, but you can't change a thing. That's not what the Village of Fayetteville Code says, and this is right in the code, right in the record. It says non-conforming uses and structures, and we're dealing with a structure here, are continued, and they can be used, repaired, and maintained. And with respect to structures, it goes even farther, and whereas many other zoning codes throughout the state and throughout the country will say you can never increase a nonconformity, it actually says you can increase the size of a non-conforming structure if you get a special use permit. You can't do that for a use, which isn't involved here, but you can do that for a structure. So this is, my point here is that you have to look at the particulars of this code, and I think that's why zoning boards, in particular municipalities, are given deference by courts in interpreting their codes, is that not every code is the same. And the Village of Fayetteville Zoning Board here interpreted the very particular language in this code as allowing this project. And the other somewhat unusual and particular language in this code is the definition of structure. It's not defined as just a building. It's defined as anything constructed or erected that requires attachment to the ground. It's a very broad definition, both of what a structure is and what you can do with a non-conforming structure. And interpretation here, I think, was clearly correct. Actually, I don't even think you have to give the ZBA deference because it was clearly a correct decision, but I do think it's appropriate to give the ZBA deference here. I believe that this was clearly an application of the law and the interpretation of the code to the facts of this particular project. And if you look at the actual interpretation of the zoning board that was on appeal to the trial court and is now here, it specifically references this project and says that by reducing the size of the nonconforming structure, that's a benefit to the community. And it further adopts the findings of the code enforcement officer, which are also in the record, and they provide a more extensive discussion of the particulars of this project, because that's what the code enforcement officer and then the zoning board of appeals were doing here. They were applying interpreting the code as it applies to a particular project.
Was it the code enforcement officer's interpretation that by taking everything down to the slab, the foundation, as a structure, that the alterations would include, for example, making sure that whatever was put up there adhered to the building code, the fire codes had to be adhered to, the plumbing, et cetera, all had to be adhered to on the rebuild, which was also a it was non-conforming, continuation of the non-conforming use, right? And so, but those alterations would have to be done, right?
That's correct. That was the code enforcement officer's reasoning, was that everybody's subject to the building code, to the state building code, and that requires alterations in some situations such as this. So it's a reasonable interpretation of our code that it constitutes use, maintenance, and repair of a non-conforming structure when you do required alterations under the building code.
And those terms are not defined in the code, right?
That's correct.
Yeah.
That's correct. The term structure is. But,
right.
And I also think that relates to another point that we discussed in our briefs, which is that the reconstruction of this structure in this project is clearly consistent with the purpose of the code, because it does, the purpose of the code is to allow the use of non-conforming structures, but it imposes nonconformity. Here you're actually decreasing the nonconformity considerably. And I think it's interesting to consider that in this case, there's really no dispute that it would be a lawful non-conforming structure if the applicant were to simply take the entire existing 137,000-foot dilapidated industrial building and put something in there. That's a lawful non-conforming structure. Here, what they're actually doing is substantially reducing the nonconformity and improving the project, and I think that seems clearly to be consistent with the purpose of the code. And I do think that it's also an interpretation, an interpretation that applies the law to the particular project. I think this court's decision in the clear case is...
Was there also an opinion by the code enforcement officer that the brownfield cleanup would be considered a repair of the property, and it's in a very important aspect of this project?
That's right, and it's the same idea as the alterations. Again, that some changes are required by law, and so in interpreting what our code means by lawful use of repair and maintenance, you should consider that. And again, the zoning board, while they didn't explicitly repeat that reasoning, if you look at the end of the zoning board interpretation, it specifically says we adopt the interpretation and the finding statement of the code enforcement officer. So I think the zoning board did a good job here of balancing all the interests and applying the interpreting the particular language of the Fayetteville Code in a way that makes sense.
Thank you, Councilman.
Thank you.
Good morning. May it please the court. Kathleen Bennett with Bond, Shenick & King for Northwood Real Estate Ventures. Northwood is the contract vendee of the property at 547 East Genesee Street in the village and has obtained approvals to reuse portions of the existing structure in connection with the construction of a 56,500 square foot grocery store, a use which is permitted under the village zoning code. So whether the ZBA's interpretation is one of pure legal interpretation or involved the application of the zoning code to the facts of this case, is somewhat irrelevant. The lower court's decision and order upholding the ZBA's determination should be affirmed, as it was based on the relevant proof in the record. It is in accordance with the well-settled rules of statutory interpretation, and it is consistent with the law concerning nonconformities. With respect to statutory interpretation of the zoning code, the primary consideration is that zoning codes are in derogation of the common law, and any ambiguities must be interpreted in favor of the property owner. Next, if terms are defined in the zoning code, they must be construed in accordance with that definition. And finally, the zoning code must be read as a whole to give effect to all its parts. As noted by the lower court, the ZBA's determination did all of these things, while the appellant's arguments below and on appeal ignore them. Here, as noted by the village's attorney, the zoning code not only permits the continuation of nonconforming structures, it permits those structures to be used for any lawful purpose, to be repaired, to be maintained, and even to be increased in size, including increasing the degree of nonconformity. Despite appellant's assertion to the contrary, this provision was not eliminated by virtue of the village's adoption of a 10,000 square foot limit on building size. In fact, this provision uniformly protects all pre-existing buildings that exceeded 10,000 square feet as of the date of that amendment. If the town board wanted to eliminate non-conforming structures, then it certainly could have modified that provision at the same time that it adopted the 10,000 square foot building limit. It did not do so. Yet the appellant would have the court interpret the zoning code as if the town board had intended to eliminate those provisions with respect to non-conforming structures. Such a reading impermissibly expands the reach of the code and is not proper. Appellant would also have the court ignore the definition of structure found in the code. As noted, structure is very specifically defined as anything constructed or erected, the use of which requires location on the ground or attachment to something having a location on the ground. That's the definition of structure. Doesn't matter whether it's primary, doesn't matter whether it's accessory. That's the definition of a structure. As noted by the code officer and the ZBA, this definition includes the slab, foundations, and footers. So the ZBA, relying on these very specific code provisions relating to non-conforming structures and the code's definition of structure, concluded that because the code allows non-conforming structures to be increased, it was illogical to say that they could not be reduced. For example, the ZBA noted that Northwood could construct a 150,000 square foot grocery store without a variance. So it was logical to conclude that they could construct a 56,000 square foot store, which would reduce the degree of nonconformity, making the property more compliant with the code, a determination that was also consistent with the law of the state concerning nonconformities. Therefore, the lower court properly found that the ZBA's determination was rational and consistent with both the rules of statutory interpretation and nonconformities. Appellant's arguments, on the other hand, would favor some provisions of the code over others, ignore specific definitions in the code, add procedures not required by the code, and interpret the code in a manner more favorable to the village.
Counsel,
all in contravention.
What about the issue of deference to the ZBA? That was a major point of counsel that we shouldn't give deference.
It's our position that deference is required here, that this was not a pure legal interpretation, because it is the ZBA considering what is a repair, what is maintenance. It's applying that information to the definition of the structure and then taking the provisions related to non-conforming structures and saying, okay, it says you can increase them, so we think, therefore, it's logical that you can decrease them. So it is interpreting its own code. It's not a
Thank you.
legal question. So as such, the lower court decision should be affirmed.
Thank you, counsel.
Thank you.
Good morning. May it please the court, I'm Kevin Rowe from Barclay Denman on behalf of the property owner, FUBU Environmental Services. I'm quite confident the court has our arguments. I won't spend a lot of your time. I do want to speak to deference just a little bit, if you don't mind. I don't buy into the dichotomy that the appellant is advancing here, that there's no deference when it's a pure legal question and only deference where there is an application of law to the specific facts. I think the case law, especially in this department, it's pretty clear that there's deference whenever there's an ambiguity in the zoning code or a gap, a lack of definition, as Justice Kern pointed out. And I think the cases bear out that when this court tends to step in and overturn an interpretation, it's where the zoning board has not adhered to the principle that ambiguity should be resolved in favor of the property owner and that kind of thing. Of course, it's always the court's job to interpret the law, but that doesn't mean that there shouldn't be deference where there are ambiguities and there is room for interpretation to the body that is local, understands how the zoning code is put together, understands local circumstances. So that's what I think. But I think it's also interesting to note that while the appellant argues that there should be no deference because this is a pure legal question, the very next point is...
That was going to be my next question.
The very next point is, but this can't be right. This particular one where you're tearing down everything except for the foundation, that's purely application to this specific set of facts. So there's a little bit of, I think, hypocrisy in those two, there's a little, I shouldn't say hypocrisy, conflict between those two arguments. So that's really all I wanted to say. I think that the court has the arguments.
Thank you, counsel. Case 757, Giazzi versus 5775 Melu Drive et al. Counsel, yes, are you arguing in this?
I am. I wasn't sure the order you would want to hear us, Your Honors. When we filed our notices of appeal, I wasn't sure if I was going to also be responding. As the briefs came in, it became evident that I'm a pure appellant.
Right.
Perhaps
Well,
I
you should
go
sit at the
first.
appellant's table,
Oh.
that's my only point. That's fine. Proceed, counsel.
Good morning, Your Honors. May it please the court. My name is Jacob Purkowski, and I'm here on behalf of the plaintiff, Carrie Giazzi, in relation to her January 2016 slip and fall at 5775 Melu Drive in Hamburg. I'm sure the court is familiar with the facts of this case. It's a slip and fall on ice case, but there's some interesting issues here which I think really create questions of fact as it pertains to the respondent property owner. The first of those, I think, is the lease itself speaks to the fact that the property owner was not a out-of-possession landlord. At the very minimum, there's questions of fact to this issue. The language of the lease alone is very clear. This landlord had the ability to inspect the property without notice, had unfettered access to the property, could inspect the books and records of the property, and could functionally inspect all aspects of the business of this property. This wasn't just a landlord who comes in to say, hey, I want to make sure that this building is structurally sound, or that you're keeping up with the appearances, or that the sign is in accord with the restrictions of the lease. This was complete access to the property at any time without notice, and for those reasons, I don't believe that the lower court was correct in deciding that they were not an out-of-possession landlord. I think they were very much involved and had a lot of oversight into what the landowner, or what the tenant was doing.
Counselor?
Yes, Your Honor.
Could the landlord compel repairs?
The landlord could compel, well, it's interesting how it's drafted. The landlord could, with 3 days' notice, the landlord can compel the tenant to deposit 120% of the value of the repairs or maintenance. So if they identified that there was a problem with the landlord, a problem with the property, they could demand that the tenant pay them 120% of the money, if the money, 120% of the cost of the repairs, And if the repairs were done sufficiently, then they would receive back the 20% overage that they paid. So I've never seen that in a lease before, but there's an unusual way to compel because they can charge them 20% more than what the repairs are going to cost.
They can encourage the repairs by exacting 120%, but they couldn't compel under the lease, right?
I guess I would argue that they could, because they're holding this extreme amount of money, and therefore, even if they did not, if the tenant didn't make the repairs, then the way the lease reads leaves it up to the landlord to make those repairs on their own. So one way or the other, the repairs get done, whether they're holding the tenant's money or the tenant's doing them proactively. So I think that issue is really unusual in a commercial lease something I've never seen before, and it goes to the fact that there is a question of fact as to whether they were not a possession landlord or not. The second thing, Your Honors, is the defendant's witness, Richard Cleland, testifies on multiple occasions that the defendant was the tenant. He testifies that the defendant, 5775 Maylew Drive, was the entity that contracted with the snowplow company. He testifies that they had the ability to run the nursing home that was on the property. So, at a bare minimum, there is a credibility issue and a question of fact to this, because their only witness that they provide, who was the administrative director of the defendant's company, or acting administrative director at the time of the deposition, says, oh, we were the ones who contracted with the snowplow company. Oh, we were the ones that ran the nursing home. And this is in direct conflict with all the other evidence. So that credibility issue right there is a question of fact regarding the possession and control that the landlord had. The second point here, I think, is this issue of the alter ego. The standards set forth by the courts are very, very clear and very comprehensive as to what makes a company an alter ego of another. I don't think there's anything in the record that the defendants have put forth that satisfies a single one of the factors in any of the cases we cite in our brief. Certainly there's no common purpose that's set forth by the defendants. Certainly there's no integrated or commingled assets that the defendants allege. And this is from Butchwald v. 1307 Porterville Road. There's no shared tax return that they put forth. There's no treatment by the owners as a single entity. And there's no shared insurance policy. All they had to do was put any of this forth in the responding papers. They don't. I don't think there's any cognizable argument that these are an alter ego. The best they have is that the treasurer signed the lease for the tenant and the landlord. That's the best argument they put forth. But that's not one of the standards contemplated by the cases. So for those reasons, I think that there's real questions of fact regarding the out-of-possession nature of the landlord here. And I rest my papers unless there's any other questions from the courts.
Counsel, you don't want to address Lange's? This is your opportunity.
Oh, I can, yes. I'm sorry. I didn't know if we want to do that separately. Or
You're not going to get another chance at the podium, so you better do it now.
Let's do it now. Yeah, I think the Espinal argument's interesting. So the court, I would agree with the lower court in this ruling that they were correct that there's questions of fact regarding Espinal here and how it applies to the third-party contractor. The first standard, the comprehensive nature of the contract. There's nobody else who is permitted to perform snow removal. The best testimony that the defendant offers is that occasionally the defendant would clear snow around the enclosure surrounding the dumpster. I don't think this is what Espinal was contemplating. When the property maintenance manager is questioned, he gives very specific areas in which he was responsible for. He says sidewalks, he says grounds, he says all these different areas. He never says the parking lot, never says they're responsible for it. When asked if he ever cleared snow for employees as they were going to their cars, he said we did, but I don't remember doing it that year. So there's one group that's responsible for removing the snow, and that's Michael Lang, the respondent in this. Moreover, Lang has incredible discretion as to when he's going to apply salt, when he's going to remove snow, when he's going to perform his duties. He testifies on multiple occasions he doesn't have to check with the company that he contracts with. He can use his own discretion. He lives close by, he drives by, he checks the property, he checks the weather. This is all on him. The second factor under Espinal is that the plaintiff detrimentally relied on the services provided by the snowplow contractor. And we know this because Daniel Geary, who's the property maintenance manager, says the word, we relied on Michael Lang to plow the property, or plow the parking lot. I don't know what else we can offer in that respect. That's as clear as it gets. They're relying on this service to come plow the property. The defendants make a lot of argument about that the plaintiff didn't know the specific company or was unaware of the specifics that there was a contracted for company. I don't see anything in the case law that there's a requirement that they're aware of who's actually doing it, just that they're aware that it's done.
So you're talking about snow removal. However, this is a case where the plaintiff fell on ice.
Yes, right.
Ice between the cars, and ice that I think she argues that, foreign because of the way the snow was plowed and then the freeze-thaw cycle thereafter created a dangerous condition. Is that your argument?
That's my argument, Your Honor. Yes. And that's the third point, that this launch a force of instrument or harm, the condition was exacerbated by Michael Lang's inability or inactivity in applying salt in the 4 days since, so he applies salt on January 11th, she falls on the 15th. Her testimony is that in the week leading up to her fall, the snow cover, or the ice cover in the parking lot is increasing daily. She arrives at work before 6 in the morning, it's frozen, she leaves around 2 o'clock, it's starting to melt. And she sees every day it's getting worse and worse. And there's a myriad of complaints. I mean, we know this. 2 people fell, another colleague fell on the day after she fell. We had falls going on throughout the winter. This was a common occurrence or a common discussion amongst the employees.
And she complained before she fell.
Yes.
When she came into work that morning, hey, folks, it's slippery and icy, and she uses both of those terms.
Yes. And for those reasons, I think that the Espinal defense put forth by the defendants, there's questions of fact to it. I think there has to be.
We'll take a look at that, counsel. Thank you.
Thank you so much.
May it please the court, Justin Hendricks on behalf of the Lang defendant appellants. I'll jump in right there where we left off about the complaints. Your Honor, those complaints went to Geary.
Right, they weren't made directly to you.
And they were not relayed to us. So that's the first problem with that. And the second problem with that, of course, goes to the reliance. That this whole issue of reliance really is only created because of the affidavit that was submitted in support of the arguments against summary judgment on the issue of Espinal. The deposition testimony is completely different than what's in that affidavit. And you can tell that very clearly when you go through the brief, because when there are sections from the deposition testimony that are setting the scene, it cites to the deposition testimony. But once they get to the statements that they need to be able to try and establish detrimental reliance, all of a sudden all the citations switch over to the affidavit. And that's because the deposition testimony was crystal clear, and you only need to take a look at the record at 422, basically the entire argument, and then it's repeated again at 506. It's in my brief. I don't have that number off the top of my head. But she couldn't be more clear that she did not know who plowed. She didn't know if it was an outside contractor or if it was just someone that her employees went out there. And then, Your Honor, you brought up, Justice Bannister, the fact that it was between the cars. Geary, who is the representative of the employer of the plaintiff, says clearly that it wasn't Lang's responsibility to go between the cars, and that at no point was he directed to go between the cars.
So whose responsibility was it to get between the cars?
The property owner, Geary's, I mean, whoever's taking care of the property.
Okay, but then they further argue, I'm so sorry, that, it wasn't just the failure to clean between the cars, but how it was cleaned contributed to that freeze-thaw cycle, which made it dangerous in between the cars.
Yes, and again, I'm glad all these points are getting brought up, so the court's clearly aware of these issues. That exact argument has certainly been made, and I believe it was the Hannigan case from the 3rd Department that the plaintiff cited to within their brief. And you'll note that that case had a meteorologist and an architect in order to meet the burden of establishing that freeze-thaw situation. And the freeze-thaw situation comes up only in the plaintiff's affidavit, never comes up in the deposition testimony. I don't believe it's in the verified bill of particulars either.
Counsel, she says she's personally experienced the freeze and thaw. She said it's because the fact that your client was pushing the snow up against the dumpsters, it was thawing, and then the ice was continuing to build up where she parks.
And again, even assuming that is true, and I don't think the affidavit is worth the ink that it was printed on, but even assuming that was true, it doesn't change the fact that Lang was pushing the snow to the exact location that the contract told him to push the snow to. He's merely following the terms of the contract as set forth by his hirer, which again is the plaintiff's employer. He's not.
Okay, so is it the plaintiff's employer or is it the owner of the building?
I don't know, and frankly, I don't think it's my place to know. That's certainly an argument between co-counsel, so I'm not going to speak to that because I've not briefed that, and I don't think it's my place to say. But I would say that it's not part of the contract, and it's not the expectation of Lang. And if this court looks at its own decision from 6 years ago in Lingenfelter, you cannot find that the snowplow contractor is somehow negligent for merely failing to be an instrument of good. And that's what I would say this whole argument comes down to, that he should have gone, I guess, above and beyond the terms of his contract, that he should have been out there when there were less than 2 inches of snow, even though the contract only calls for 2 inches of snow.
We'll take a look at that, counsel. Thank you.
Thank you, Your Honor. If there are no other questions, I will rest.
Thank you.
Good morning. May it please the court. Megan Brown on behalf of the defendant respondent 5775 Maylou Drive LLC, which is the property owner. And we submit that the order that dismissed the complaint against 5775 Maylou Drive should be affirmed because there is no issue of fact that they were an out-of-possession landlord at the time of this slip and fall. And the lease...
Meaning that they were or they weren't?
They were not. They were... Oh, did I miss... They were an out-of-possession landlord. No issue of fact. That's my point. Okay. I may have misspoken there, and I apologize. Thank you for that. The lease is pretty clear, or I would say it's very clear, at section 5.1, which is in page 308, that the tenant is responsible for maintenance and repair. And this isn't a repair issue, this is a maintenance issue. And 7.2 of the lease at page 313 of the record discusses the landlord's right of reentry, which is limited to certain specified situations, major repairs, and then checking the books and how the entity is running. And I would submit this is very similar lease language to the lease that was at issue in the very recent case from this court of Black versus 465 Payne Avenue. It just came out October 6th. I know Judge Del Conte was on the panel in that one, and that affirmed a dismissal against property owner as an out-of-possession landlord, and I think the same result is required here. And unless there's...
I just have the very last question. The issue that we've been discussing about the freeze and thaw.
Yes.
And you being sort of, not you personally, your client being responsible for, setting that up by the way that they did their job. What do you say about that?
I would say that the snowplow contract was with the, I think the language of the snowplow contract says it's with Elderwood, which is the nursing home that was operating in the space. And so I would say that is clearly a contract with the tenant, and that it further evidences the out-of-possession landlord status of the property owner because the tenant entered into that snowplow contract. And I think that brings it within the Adolph case from this court where the lease was silent as to snow and ice, but there was still an out-of-possession landlord status.
Thank you.
Thank you, counsel. Case 759, Sleeman versus Sleeman. Yeah, yes, I think we're waiting for Mr. DePasquale. Am I? Oh, he hasn't checked in. Okay, very good. Thank you. Counsel Friedman, can you hear us?
Your Honor, can you hear me?
We can hear you fine. Counsel Connell, can you hear us?
Yes, thank you. And Judge, I would let the panel know that I received an email from Mr. DePasquale this morning that he was going to be submitting on his brief as he was not feeling well.
Very good. Thank you for that update. We appreciate that. Please proceed, counsel.
Good morning, Your Honors. May it please the court, Catherine Friedman representing Appellate Ed Sleeman. Your Honor, I think this represents one of those cases where it is very clear what should have happened procedurally below.
Okay, I'm going to ask you, stop, Katie. Oh, you got to stop moving around. I can't, I'm not able to hear you.
Yeah, Counsel, you're breaking up a little bit, so my suggestion would be that if you speak a little more slowly and without moving around, you may come across better.
Okay, I'll try.
All right, very good. Thank you.
Okay, so I'll start again. This appeal represents one of those cases where it is very clear what should have happened procedurally below, and that in fact did not happen. The law of this state, the Court of Appeals, and this court's own precedent states very clearly that in order to set aside a settlement agreement, it can only be done via affirmative defense, a counterclaim, or commencement of a plenary action. That did not happen here, and respectfully, Your Honors, I submit that this court must reverse the trial court order and remit to a court and either direct the court below to grant the divorce, or this court can do that itself.
Thank you, Counsel. Anything further?
Unless you have any questions, Your Honor, no.
Very good. Thank you. Counsel Connell?
Yes, thank you. May it please the court, I would at the outset adopt all of the arguments made by Mr. DePasquale in his brief, and let this court know that I have had the pleasure of representing my client, and he is a delightful young man. And I hope the court has already been informed that counsel for the appellant corrected her assertion that she put in her reply brief that I did not meet with him. That is flat out wrong. I met with my client, and I believe Ms. Friedman did send a letter to the court indicating that. And as of last week, when I spoke with him, there continues to be an order of protection in his favor. All his father is allowed to do is coach and attend his sporting events, and they speak on the phone weekly. There's been no other in-person access for over a year, and frankly, this arrangement is fine with my client. With regard to the issues before the court, I think it's very clear that the judgment below should be affirmed. All of my arguments in my brief support both the express wishes of my client and what's in his best interests. The mother should and was allowed to amend her answer to raise her affirmative defenses: fraud, duress, coercion, overreaching, unconscionability, lack of financial disclosure, and lack of legal representation. And I think the record amply supports this. Especially, I would draw your attention to the audio and video, which is in the record, showing the words and actions of the father, which support almost every one of the affirmative defenses. And the court further found that the PSA was unconscionable due to, among other things, financial inequity. And this directly affects my client's standard of living. There should have been a full disclosure so that maintenance and child support could have been properly determined. And what is most unconscionable is that the PSA provided no inquiry into best interests with regard to my client should there be any change in the mother's engagement or marital status. All of those factors and what the arguments in my brief support that the lower court decision should be affirmed in all respects.
Thank you, Counsel.
Thank you.
Case 761, Harbinger versus Cato, MD. Proceed, Counsel.
Good morning, Your Honors. May it please the Court, Andrew Borelli on behalf of Dr. Cato. As I see this appeal, Your Honors, it really boils down to the question of whether or not plaintiffs met their shifted burden in opposition to Dr. Cato's summary judgment motion. And as indicated in my papers, I submit that they did not. With respect to standard of care, I see it as really 3 points that there seems to be discussion over. First, whether or not this diagnosis of polyarteritis nodosa, PAN, could be made vis-a-vis this angiographic evidence. On that point, there is no dispute here that or at least as far as I can tell from plaintiff's expert affirmation, that Dr. Cato was entitled to rely on the review of the visceral angiograms that was done by Dr. Carmel in both 2015 and 16. At that point, he had already determined that the patient met 2 of the 10 criteria for diagnosing PAN, both the weight loss and the biopsy, which I'll get to next. And therefore, when he received notice that the angiogram came back consistent with PAN, diagnosed the patient as such, and there's no dispute he could rely on that. I think it's worth noting, too, that the plaintiff's argument on this point might be a bit undermined by the fact that the subsequent treating providers on which they rely from all over, Penn Medicine, Cleveland Clinic, and so on, all came to the conclusion there was no PAN after another radiologist had looked at those films. So clearly, these physicians rely on radiology as one of those elements in diagnosing the condition. That brings me to my next point about the biopsy. I think it's my position, plaintiff's expert is conclusory on that point. Biopsy what? Throughout the affidavit of plaintiff's expert refers to a nerve biopsy, a skin biopsy, muscle biopsy. Where should Dr. Cato biopsy? It's left entirely unsaid. And the fact that the plaintiff relies on a biopsy that was taken a year after Dr. Cato treated the patient really amounts to hindsight reasoning, because that patient's condition had changed such that the biopsy was necessary of the skin. And then the third point in standard of care I think I'd like to address would be the failure to prescribe Nesna with the Cytoxan drug if in fact PAN was an appropriate diagnosis. And the plaintiff's position on this is woefully deficient in my opinion, because it's based on a study that was done in 2022, which fails for a couple of reasons. One, this care occurred in 2015 and 2016, and there's been no opinion or evidence that that study in 2022, first of all, would have been applicable in 2015 and 16 when this patient was being treated by my client. And secondly, the substance of that study isn't applicable because that study relied on or concerned giving this drug Cytoxan to patients in high dose and patients involving chemotherapy. Ms. Harbinger was given a low dose of Cytoxan, and she was not a chemotherapy patient. This was about rheumatic disease. So that entire study doesn't hold weight, and the plaintiff's expert's opinion on this point is certainly not probative. And finally, it's my position that plaintiffs fail to meet their shifted burden on causation. First, plaintiff's expert spends a lengthy amount of time in paragraph 14 of the affirmation going through, I count at least 11 side effects of this drug Cytoxan. Nowhere in that list is lack of bladder control, which is the claimed injury, physical injury here. Not to mention the attenuated nature of this claim, because she, per the records of Dr. Cato, all the subsequent treating providers at Penn Medicine, Cleveland Clinic, Mount Sinai, did she ever report any bladder issues? It only is reported for the first time in the medical records in March 2018 with a urologist by the name of Dr. Eichel. So it's my position, not only is this not a known side effect, but it's also far too attenuated to be related to the use of Cytoxan, which had ceased almost 2 years prior.
Just at least one question for me is that when a defendant moves for summary judgment in this situation, in a malpractice case or even negligence case generally, on the issue of causation, doesn't the defendant at least conceptually have to make a point that says, well, even if you assume negligence, even if you assume deviation, whatever that deviation or negligence was not a proximate cause at all, to add that in, of the injury. So did you do that here? That is, did you assume in your motion papers that there was negligence or was a deviation and then say, but in any event, there's no causation?
Couple of points on that, Your Honor. First, I don't believe plaintiff raised this issue until appeal. It was in his papers below, but secondly, I do believe, while it may not have been in those exact words, our expert did in fact say that he did also discuss the known side effects of the Cytoxin, so the patient never developed any of those known side effects as a result of using the drug. Therefore, no cause of the bladder injury.
But that doesn't say that even if I misprescribed, even if the doctor misprescribed, it didn't cause any injury. I think you kind of have to assume the negligence when you move for summary judgment on causation, don't you think? Just for the sake of argument.
I don't know if that's necessarily true. I think you could say you didn't deviate and still say that anything you did or did not do, that anything the physician did or did not do did not cause the patient's injury. I don't think you have to concede or assume.
I'm not asking you to concede.
Assume it. I don't know if it's necessarily true. But
Thank you.
Unless there are any other questions, I'd rest.
No questions, counsel.
Thank you very much, Your Honors.
May it please the court, Robert Julian for the respondent. As to the issue of whether or not there are questions of fact, Judge Antonacci, we believe, got it right. This is a classic battle of the experts. The issue is not angiographic evidence. There are one must have at least 3 criterion in order to diagnose PAN. In this case, Dr. Cato relied upon neuropathy or polyneuropathy, one of the standards set forth by the American Academy of Rheumatology. It is our expert's position that to make that diagnosis, one must have fact and that a biopsy is indicated. Indeed, Dr. Cato utilized another less reliable test, an EMG, which proved that the condition was not present. Neither condition was present. So there is a deviation from the standard of care identified, and Dr. Cato did not have sufficient criterion to make this diagnosis, and indeed had an EMG study which suggested quite to the contrary that this diagnosis was not indicated. With regard to the issue of causation, Judge Curran, I believe it's the Berber case, followed by the Fagnoli case, which I had the privilege of arguing against my learned counsel's office, in which this court said what you said, and that is if you're going to argue causation as part of your summary judgment motion, you, the defendant, need to put that argument forth. It was not put forth in this case in any manner, shape, or form. So with that, unless there are any questions.
No questions, counsel. Thank you.
Thank you so much.
Case 762, Atchison versus Pelliccia. Thank you. My apologies.
Morning. May it please the court, Nathan Van Loon for Lynn Atchison. Judges, this is an appeal from a summary judgment decision, and it all comes down to an issue of credibility. And I believe that.
Is that what you think it comes down to, a question of credibility?
I do in a large respect, but in a larger respect, we've got another issue, which is whether the property condition disclosure statements even matter anymore. Because we have a situation here in this case where the question was, they're twofold. One was about asbestos and whether it existed on the property or not. And you have an option, yes, no, I don't know, or not applicable. Mr. Pelliccia said no. And it turns out, yes, there is asbestos in the house.
But then what does as is mean?
Well, as is means as is after the fact. But in this circumstance, she relied upon the property condition disclosure statement to make her decision as whether to bid on the house and buy the house. So it was very important that those answers be correct. And it turns out they weren't correct.
Was this a situation, remind me of the record here, was this a situation where your client lived out of state and did this transaction, I think a lot of it through text, email, whatever it was done, and didn't do or didn't hire somebody to do an inspection on the residence.
That is correct.
Okay.
She lived
It
out of
was
state.
available, but chose not to do it.
Well, if it's available when you have 27 other folks that say they're going to waive their inspection, I don't know if that in reality makes it available or not. Judge, we live in a different environment than the environment where I got my first house, which was an inspection was pretty much standard. Right now, with the market as it is, if you put down that you want an inspection, you're going to go likely to get overlooked.
Isn't that a choice that's made? The choice is made to not do an inspection. That's what's troubling here, and I understand that the pressure of the market as it exists today, and people are feeling like they're forced to waive an inspection in some circumstances. But that's a choice that's being made, right? And it's a as-is purchase, is it not?
The choice was made, Judge. However, like I said, she relied on that property condition disclosure statement.
All right, very good. Anything further?
Nothing further.
Thank you.
May it please the court, Your Honors, Rick Brister on behalf of the respondent. Your Honor, it sounds like you're all over my brief. The focus that plaintiff is making, or that the appellant is making here, is really on the credibility of the witnesses. If you look at my third argument, I argue that they completely ignored all of the arguments that we made regarding whether the property was purchased in an as-is condition, or whether there was a specific disclaimer to the condition of the property, whether the conduct of my client thwarted the buyer's ability to do those inspections, whether there was any active concealment. The judge raised all of these issues below, and they weren't addressed in the papers. And my initial contention is that those issues have been abandoned. But we're here, so let's talk about them. The issue of misrepresentation. Plaintiff argues, or the appellant argues, that all competent evidence must be viewed in light of the most favorable to the non-movement. The problem in this case, though, is there was no competent summary judgment evidence submitted in this case.
Counsel, let me ask you a question. The contract itself was admitted, right?
That's correct.
And in it indicated the items of disclosure, that there was no problems with certain things. Didn't the plaintiff have a right to rely on the disclosure agreement that was a part of the contract? And isn't that competent evidence?
No, Your Honor, because we are in what's called a caveat emptor state, a buyer beware state. The seller is not required to disclose any information on the condition of the property.
But they are required to complete the disclosure statement, and
They
they're
are,
required to complete it correctly.
That is correct, and they are required to base that on their actual knowledge. What the appellant is proposing here, if you look at their argument, they said, well, Mr. Palikia should have known, or he must have known, because he lived in the house for 34 years and he did a bunch of renovation work. Initially, that is simply constructive knowledge. That is not actual knowledge. And if you look at the PCDS, the property disclosure statement, you'll see that at least 5 times it mentions that you have to answer, that the seller is answering based on his actual knowledge. So constructive knowledge is not the test. I would also point out that we're cognizant of a requirement that the seller not actively conceal a condition of the property. The judge commented on that in the trial court below. But in order to establish active concealment, what the appellant must show is that the seller thwarted the ability of the plaintiff to fulfill the buyer's responsibilities under this doctrine of caveat emptor, which is what you were talking about, Justice Whalen, and that is to get inspections, to get environmental testing done, to review the public records. They had those options available to them. She opted to forego those options. And And this is,
Well, plaintiff wanted the property. Okay.
Pardon me?
Plaintiff wanted to buy the property.
Yes, sir.
Okay, and she
Yes,
was
sir.
competing. Okay, and if she said no, somebody else was going to buy the property. So they decided to take it as is with no inspection. That's really the bottom line.
that is essentially the bottom line. We are a caveat emptor estate, and they had those duties to do that. And if you don't have any other questions, or if you want to talk about the water and sewer line, we can talk about that as well.
No questions, Counsel.
Thank you, Judge.
Thank you. We're going to take the next case out of order, case 765, Graham versus City of Syracuse. Counsel, proceed.
Good morning, Your Honors. May it please the Court, my name is Danielle Smith, and I represent the City of Syracuse in this matter. The City's argument on appeal is twofold. First, the trial court failed to consider the City's alternative argument when it comes to prior written notice. The Court of Appeals is clear that prior written notice must reference a specific location. The mayor's email, which plaintiffs argue constitutes prior written notice, covered 3 streets and many miles of city streets. That email is hardly specific. The third department in Dalton v. Saratoga Springs rejected a prior written notice argument for a deteriorating sidewalk on the west side of the park. The second department in Fraser v. City of New York rejected a prior written notice argument for holes in a stretch of roadway covering about 400 feet. Respectfully, the mayor's email is far less specific, covering far more ground than the 400 feet. But even if it constitutes prior written notice, the mayor's email was resolved 2 days later.
Counselor, in the PJI, there's a section 225A that applies this situation. And reading it, it says, one of the questions the jury can be asked is, if you find that CD, being the city, did not receive prior written notice, or that the written notice CD received did not identify the location and condition that AB claims caused her injury. So can't whether or not you received written notice be a question of fact, first question, and second, can't whether or not the written notice sufficiently identified the location and condition, can that also not be, that can be a question of fact too, right? Based on what I just read, both things can be a question of fact.
If I understand your questions, or Your Honor's question.
That wasn't a very clear question, either one of them. I'm sorry about that. But.
No, if I understand it correctly, yes, I believe both can be a question of fact. Whether the DPW commissioner physically received a document could be a question of fact as to whether that is prior written notice, whether that was a written document, whether that was transcribed from a phone call. Those could all be questions of fact as to prior written notice.
Shouldn't the jury decide here whether the city got notice by virtue of the emails from the mayor and by virtue of the complaints that were received in 2019? I know your argument is, hey, wait a second, they were repaired or they were somewhere different. I know that's your argument, but isn't that the question of fact that a jury needs to look at?
Well, I think also we have to look at the city charter, which includes language that says that the city must resolve that issue within a reasonable amount of time, in which case I think essentially the situation gets reset to zero. And this mayor's email from February 2018 was absolutely resolved in a reasonable amount of time. It was resolved 2 days later.
And how was that resolved?
The areas were patched, Your Honor.
Okay, cold patched?
Yes.
Okay.
Yes, they would have been a cold patch in February.
So even assuming you had written notice, you'd say you fulfilled your duty?
Correct, Your Honor. Yes. But even if it is constitutes prior written notice, again, it was resolved, which leads us to the second question of affirmative negligence. Plaintiffs must establish affirmative negligence. They have the burden of proof. They must come forward with evidence that the defect was immediately present. Now, the city's briefing discussed
First, you have to carry your burden.
I'm sorry, Your Honor?
First, you have to carry your burden on this issue.
Our burden is prior written notice. Once prior written notice is established, the burden then shifts to the plaintiff to demonstrate, to come forward with evidence.
Do you have to move on that issue yourself?
No, Your Honor.
Just written notice is enough?
We have to establish written notice. It then becomes the plaintiff's burden of proof.
Counsel, I'm so sorry.
Oh,
I know
no.
you want to get to your argument.
Of course.
All right, so the notice question, okay? Based on what the mayor said, you went out and did something.
Correct, Your
okay?
Honor.
So isn't that proof that you had notice of that particular problem with the roadway? Because you went out and fixed it.
Well, I think we have to take a step back and look at what that mayor's email said. That mayor's email referenced potholes on 3 city streets, which encompasses about 3 miles of city streets. Did not say specifically at 766 Irving Avenue, where the plaintiff claims she fell. I would also make note of the plaintiff's testimony here, which said she did not identify a pothole. She was asked, did you see a pothole before you fell? No. Did you see a pothole after you fell? All I saw was gravel.
But the notice of claim clearly says pothole.
The notice of claim says pothole, but I would respectfully submit that her deposition testimony is more conclusive in this matter. Going back to affirmative negligence, the plaintiff has not come forward with any evidence that at the time of the patching, which is their burden, that even if the city patched that area, and again, there's no proof that the city patched that specific location, but even if the city patched that specific location, there's no burden that the patching was immediately defective. And I would point to this court's decisions in Burke v. City of Rochester and Simpson v. City of Syracuse, which both discuss the plaintiff's burden on a summary judgment motion. And just in conclusion, I feel like I do have to touch on the temporary cold patch because that does get referenced to the court's decision. Plaintiffs raised that as well. The city cited a plethora of case law. A temporary cold patch is not immediately defective. And I would reference this, the Third Department's decision in Kushner v. City of Albany, which subsequently was affirmed by the Court of Appeals, wherein the court held that even if that pothole was not excavated correctly and then filled with cold patch, and that's what led to the pothole then reforming, still not affirmative negligence. Because there was no proof that the time the pothole was patched, it was immediately defective. If this court has no other questions, I will otherwise rest on my papers.
No questions, Counsel.
Thank you, Your Honor.
Good morning, may it please the court. Robert Flynn for J.K. Tobin, Salt Springs. I'll be brief. As it pertains to my client, 3 little words in a building or a permit application, at or near, seem to have undermined my efforts at summary judgment.
Your client's contract was with Syracuse University, wasn't it?
Yes, Your Honor.
So how does that create a duty to the plaintiff here?
We've argued that there is no duty to the plaintiff since we're not an owner, therefore we have no non-delegable duty. There was some permit application involving my client in other areas, but the University Place and Irving Avenue area was a contract between the city of Syracuse and my client, J.K. Tobin.
Your argument, as I understand it, is Waverly is considerably south of where this accident occurred. I mean, there's photographs that you can kind of figure out it's right across from the Marcy's, I don't know if it...
Marley.
Right. So coming across from one hall. So Waverly is considerably south of that, you would say.
That is correct, Your Honor.
But then the other one, what is the one that's crossing right above where that place is, Marcy, whatever you call it? Forgive me.
Waverly is north of the accident
Waverly's
location.
north. I got that.
And University is south.
Right.
And so...
but Waverly's right there. Right, I mean, it's right there by where the intersection is where she fell, right? But is your point that all the work that you did was north of Waverly?
Well, south of the accident site.
That's University.
That's towards University.
Well, what about Waverly?
Waverly, the work was north of the intersection.
I've got you confused, by the way.
Yes,
Sorry about
that's
that.
fine. I misunderstood your question. Yeah, the work, I believe the record establishes that the work near Waverly was north of that intersection. So plaintiff would have had to have traveled north on Irving, crossed Waverly, and then encountered any work that my client would have performed.
Supreme Court seemed to focus in part, at least, on the work permits. What about the work permits? Doesn't that place you there? At least a question of fact.
Well, the work permit at or near may place me there, but I think it's clarified in and of itself when it says that the work was performed at the intersection to facilitate better flow of pedestrian traffic. The
Which
plaintiff.
intersection?
What's that?
Which intersection? University?
Well, I believe the building permit was, or the permit application was for University, because the J.K. Tobin did have to cut into the street there to do their work. But the plaintiff did not fall at an intersection. She fell mid-block, according to the testimony and the Google map photos that were attached to the motion paper. So there's nothing that puts my client at the accident location. I think it's telling that the city of Syracuse, to their credit, didn't oppose our motion for summary judgment, didn't file any papers with respect to our appeal. They can't place us there, and for a jury to somehow place us there would be to allow them to engage in speculation. And that's our position.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the court. My name is Maria Mastriano. I represent plaintiffs in this matter. I'm not going to go through a recitation of facts because I know you don't want me to. So I'm going to just try and hit on what was brought up during oral argument and your questions as well. The first is, I'm going to just address the city of Syracuse first. First of all, I heard the counsel for the city say that this was many miles and 3 streets. We're talking about one street that was identified in that mayor's email, and it was less than a mile long. But just as Judge Bannister said, this is what I was going to bring up, is that we know that they know where that was. Even if you want to say that was vague in the abstract, because they never asked for clarification and they went out and fixed it.
But they did fix it, didn't they?
With a cold patch.
Right, and doesn't that then reset the clock?
Well, they did it with a cold patch, and we don't know, we didn't get any confirmation, not just with a cold patch, but what happened around there as well.
But wasn't it, didn't they fix it almost a year before she fell?
They did fix it a year, but according to the city's own testimony, that was just a temporary fix. A cold patch is a temporary fix.
And what's the permanent fix? When they come around and do what?
A heat patch.
Okay. And they do that in the good weather?
Hot patch, heat patch.
Yeah, they do that in the good weather when it'll stick?
In the good weather,
Okay.
that's right. Secondly, in terms of, I know that the city also said that the city line service requests don't constitute notice, even though it's the city's own system for communicating that to the commissioner. But again, it brings it back to the same point. They did go out and they did fix those areas, didn't ask for clarification, and they knew, they must have known where it was because they fixed it. Or they went out to fix it, excuse me. And in terms of the mayor's email, we know that the commissioner did receive that. And we also know that after that time period, for the ensuing 18 months, there were continuary temporary repairs over that as well, and that's in that area. So we also then move on to the service line request, which was in May of 2009 and in June of 19. And in June of 2019, again, potholes in this area. And
Counsel, did she fall in a pothole? She didn't say she fell in a pothole. Didn't she say she fell on gravel?
Your Honor, I would submit that they're cherry picking where she said that. If you look at the notice of claim, at the pictures that were attached to the notice of claim, and if you look at more closely at her deposition testimony, in one part she does say uneven ground. In another part, the question was, at what point during your crossing the street did you actually fall? Answer: I stepped off the curb onto the road, and that's when I fell forward. My leg twisted in a pothole, uneven ground that was there, and that's the record at 125. So she's using those two terms synonymously, because what else is a pothole of an uneven ground? And in terms of getting back to the service line tickets, one of them was in June of 2019, and that ticket did not say that there was a resolved repair until June of 2019, which was 7 days after the accident. So there's goes to against the city's immediacy argument.
But doesn't the city say something to the effect that that repair was north of where the accident site was?
They do, and if you look at, and this, I guess I'll kind of get into J.K. Tobin too, because they had affidavits saying that that's not where repairs happened. But let's look at what evidence that they've submitted for that. It was first of all, the work order does say on or near, okay? And it does say that they had to cut the asphalt. They weren't just working on the sidewalk. They had to cut the asphalt, and they had to also repair, let's see, they had to excavate, replacing a sewer line and a sidewalk, and then restore the pavement. But what you have in evidence that that wasn't the area are two self-serving affidavits, okay? One was from a comptroller, and in that affidavit, he never describes what his role entails that would enable him to search for documents, because, by the way, J.K. Tobin didn't produce any documents on this. The role that enables him to search for it, what he searched for, what he found, you know, and that's an issue of credibility. It's a self-serving with no data backing them up. The second affidavit is, I'm never going to be able to pronounce his name, Michael Debluski, another J.K. Tobin. And again, he has an affidavit, but he has no personal knowledge whatsoever. He didn't know when the project began. He didn't know when it ended. He didn't know what it consisted of. All he knew was to push his clients, or to push his company's position.
Counselor, with respect to the contractor, and Tobin barely touches on this point, but they cite a case that seems to be a basis for questioning the existence of a duty. And that's what I'm focused on here now for just a second. If their contract between Tobin was with Syracuse University, but it was not with the city, and as I understand, under the Espinal line of cases, it's at least with respect to launch an instrument of harm, which I think is the primary basis that you rely on here.
That's correct, Your Honor.
Well, if it's launching an instrument of harm, but you're not a third-party beneficiary of the contract, because you might be, you probably would be between the city, who is the owner that has the non-delegable duty, but Syracuse University doesn't own the property that your client fell on. So how is it that there's any duty in law whatsoever based on a contract between Syracuse, a private entity, theoretically, I think, and Tobin? I'm not sure we're even on the same page here, you know what I mean?
Yes,
what duty do we have?
I think we have two different kind of parallel tracks to get to a third-party beneficiary. One is in a contract, it would say that. But two is under Espinal. Espinal, the exception to Espinal that you don't need to be in privity is if you launch an instrument of harm.
But no, you have to be an intended third-party beneficiary, is my understanding of the Espinal analysis, at least vis-a-vis launching an instrument of harm. Do you agree or no? And don't just agree because, some judges like those.
I don't necessarily agree that you need to, it needs to be that way. But even if it was, I mean, who would be the beneficiaries of this other than the pedestrians that were walking on the street? And I think with that, I'll rest it unless you have any other questions.
No other questions, counsel. Thank you.
Thank you so much.
Case 763, Salino Law versus Looney Injury Law. Justice Ogden is recused from this case.
Good morning.
Proceed, counsel.
Good morning, Your Honors. May it please the Court, Gerald Walsh for Looney Injury Law and John Looney. I'd like to start at a place that maybe isn't as obvious as I thought it was until I looked at it again, the RJI in the case. And two cases were listed, but it's the same case, same index number. Carlicia Shaw versus Uber, and then it says, I got to take my glasses off, Salino Law versus Looney Injury Law. Both the same index number because they filed a petition in the Carlicia Shaw case. So if the Carlicia Shaw personal injury case is related to this dispute where they're trying to allocate fees in 28 cases listed in the complaint, how is it that those other 28 cases are not related? They are related. They should have been listed. The answer, we listed a related case. The form, the rule says any related case. And then it says, I affirm under the penalty of perjury that upon information and belief there are no other related actions or proceedings.
Counsel, let me ask you a question.
Yeah.
You're asking us, in essence, to set aside this RJI and have another judge take over this case as filed.
Yes.
Right. And so you haven't asked us to send this back and have these cases distributed back to the trial judges that handled them to the extent that they're still on the bench.
I haven't asked for that, but that makes the most sense to me, but I
But that's not the remedy you're seeking from us?
No.
Okay.
No. That makes the most sense.
But counsel, what you're asking is to have the complaint dismissed.
Yes.
And then this has to be restarted.
Yes.
And then the question, if it's restarted, is where should the charging liens be resolved? Should the charging liens be resolved with one judge, or should the charging liens go back to the judges who presided over the underlying action? Isn't that what you're asking us?
Yes, but I think the answer to the question is the latter. It should stay with the judges who are assigned to it, but I can't force that.
Because they're charging liens, right?
Yeah.
That's the nature of the relief that's requested here.
Yes.
To enforce the lien on the recovery in the individual actions.
Yes.
That's where it should go. And
Yes.
that's why each one of those should have been started as an individual petition.
Right.
But as presiding justice pointed out, I think that's not your argument in your brief.
That's not my argument in my brief, because I had to deal with the complaint that was served. And I said,
And on that issue, Mr. Walsh, would you agree with your learned colleague on the other side, opposition, whatever, that issue about the conversion is now moot and perhaps subject to a further appeal for all we know? That is, the court has now converted the complaint to a petition and the action to a proceeding, is what they tell us that it's moot. Do you agree?
no,
Why not?
because we moved to dismiss because it wasn't filed as a petition. And then when we finally got to a point where we were going to have hearings, I moved for a stay, and then it was denied by Justice Pinapento on the day of the hearing, that we started doing hearings. And I tried to move for a stay here, but nobody would sign an order to show cause, so we went ahead. And at that point, they had cross-moved to now convert it back to a special proceeding. And that was a strategic reason, because they hadn't filed a note of issue on their summons and complaint, and we pointed that out. So I agree with Justice Del Conte. Throw out the complaint because it was supposed to be a petition. The statute says petition.
How do we throw out a complaint that no longer exists? It's now a petition.
Because how do I respond to a petition once it's done at the hearing? They filed, after the judge ruled, and in the record she said, well, you could have filed a petition, and they filed an amended complaint, and they added 7 more cases. They chose that path. They didn't then file a petition and say, you know, you're right, we should have filed a petition because that's what the statute says. They were trying to get the jump on us by getting into court, and if they're going to do that...
You're saying there's a whole lot of strategizing going on.
Way whole lot of strategizing.
Lawyers get paid to strategize.
Yeah, but they have to do it by the rules, Judge. They didn't do it by the rules. And if go ahead, Judge.
Counselor, I think your point is that when you made the motion to dismiss the complaint because it was defective under the statute, that the remedy that this judge is relying on to convert wasn't available to her because she didn't have the authority. Those charging liens reside with the other judges.
Correct.
This isn't a plenary action against a former client.
Correct.
And it's really not an action against your particular law firm client. This is an action to recover against property that was secured, recovered in separate actions across 2 separate judicial districts.
Correct. Well,
And if the complaint is dismissed, it can be reactivated in separate petitions. That's the point you're making.
yes. And that's what we tried to do, actually, in Niagara County when they got the jump on us. We were trying to file a petition in Niagara County with Judge Caruso with 2 cases in the case. And then Niagara County, they shut off filing. So we had to file a new petition, and we did. And we listed those cases, and it got assigned to Judge Caruso. And he said, well, it looks like they filed first. Let's see what happens with the case with Judge Panapento. And that's happened with a couple other judges, too. So we think that what was done here was intentional. I think it brings up the whole question that we raised. I understand the first decision. We think it raises that question. It appears that the judge was blind to this because just didn't see. I just don't see how you can read the form and say that this was right to try to get all these cases assigned this way. There was no mistake in how this was done.
But the RJI, too, requested a preliminary conference.
No.
Right? Didn't it request, but even before the pleading was served.
Right, it was early. The rule
Right.
says after service of the plea.
So let's assume the RJA comes in, it's assigned to a judge, the judge's clerk gets it and says, okay, let's set up a preliminary conference. We don't even have counsel appearing on behalf of the defendant in that first action. How could you even begin to process that, RJ? That's your point.
Yes, and the clerk wouldn't know that. The clerk doesn't read the complaint to see there's 28 cases that they're trying to get adjudicated. Thank you.
Thank you, Counsel.
Unless there's a further question.
Good morning, Your Honors. Greg Pajak for Salino Law and Salino and Barnes. To Justice Del Conte's point, I respectfully disagree. I don't think the charging liens belong to the underlying court that heard the underlying case.
Well, counsel, isn't that what you argued last month? You said that this court should defer to Justice Panapinto in the Shaw case because she was the trial judge.
No,
That's not the case now, right? If you go.
Correct. But that's not what I said last month. The basis for my argument last month was, or the month before, whichever it was, it's kind of deja vu, is that Justice Panapinto heard the evidence, and under the standards in this state, it has to be an abuse of discretion based on her ruling that for you to then overturn her allocation of the attorney's fees. It wasn't that she was the underlying judge. She happened to be. And 475 of the judiciary law does not say that you must bring a petition before the underlying judge that heard the now closed, settled, and frankly discontinued underlying personal injury action.
Let's test that if we could, counsel. The charging lien is a creature statute.
Yes.
And it's a lien against proceeds or settlement funds that are created inside that action.
As a result of that action, correct.
As a result of that action. And without an action, there's no charging lien. And the court that presides over that action is responsible for making sure that that lien is appropriately allocated. Is that court not responsible?
No, not unless, if somebody brings a petition in front of that court or a motion. Over my years, I've also seen a motion brought before the underlying judge. I've seen motions, actions, and special proceedings. If it's brought and raised the issue in front of that underlying trial court judge, absolutely it is. But if somebody else brings a summons and complaint, starts an action in a different county, like happened in the case of, I found this for our argument.
I don't want to interrupt you, but that's the problem we have here. Nobody brought a charging lien petition. No one brought a motion to enforce the charging lien. What happened was a summons and complaint was filed in another county.
Yes.
And the motion is to dismiss that because it wasn't a petition or some other appropriate mechanism to enforce the charging lien.
But it was an appropriate mechanism because there's no requirement under 475 that it has to be a petition. The word petition is used in 475, but it doesn't mean literal petition, because if you read that sentence, it says it says the attorney or the client can petition. Petition is simply seeking redress from the court. That's a plain old English word to say, I'm asking the court for some kind of relief.
But you felt you had to move to convert to change it to a petition.
I didn't feel that I did.
It is a term of art as far as your later motion is concerned that you brought to our attention.
Correct. I did it because I was trying to appease my opponent, who was complaining at length about the fact that I did use a summons and complaint, which I think is appropriate. But I said, fine, if you want it to be called a petition, let's call it a petition, and the remedy is not outright dismissal. It is the conversion, which Judge Panapinto did. She tacitly did it in her decision that's part of this record, and then she formally did it. So again, I think because you have CPLR 104C, or 103C, which allows the court to convert, this is really a lot of form over substance, whether we call it a summons and complaint and an action, or you call it a petition, notice of petition. But to the point that the charging lien doesn't belong to the underlying judge, I came across a case which I should have remembered, and Justice Bannister, I believe, was the underlying judge on it, called Salino and Barnes versus the law offices of Christopher Cassar, where I started a lawsuit. And this court said in its decision, in commenting on the myriad of other issues, that we properly commenced an action to allocate the attorney's fees, which is exactly what I did right here. I properly commenced an action, obtained jurisdiction over the defendant. And for the sake of judicial economy, isn't it better to have all of these cases decided by a judge that's familiar with the many issues between the parties in this case. She had just held a hearing.
Well, I'm not so sure it is. I mean, there's an argument to be made that the allocation of the fees best resides with the judge that handled the case from which the fee was generated. The judge may have been involved in the pretrial conference, maybe there was a jury selection, maybe witnesses were taken. I'm not sure the status of each case, but that's kind of the point, right? That the judges are there, and we very often will defer based upon that relationship that the judge has to the case itself. And so I'm not so sure it is judicial economy. And then there's the possibility of appeals from cases that get resolved. And if the judge below handled that case, then maybe we defer to that judge's experience, having rolled up their sleeves and handled the case. But if the judge didn't do that, does the judge below have to go through and spend a lot of time that the other judge would not have?
I don't disagree with what you're saying, Your Honor. I agree that in certain circumstances, that is absolutely correct, that the underlying trial justice may, sometimes depending on the judge, have a familiarity with what went on. But you can go that route, but you don't have to go that route. That is my point.
Yeah, your argument, you're saying that it's not a jurisdictional requirement. In other words, you don't have to go to the judge and file before the judge that handled the case. You know, my experience, and I won't speak to the other members of this panel, we're all with trial judges, was that that's typically who handled these cases, would be the trial judge that was involved in disposing of the case that generated the fee. But that's just my experience in one JD within the Fourth Department. But you're saying that may be true. That may be how things are handled normally, but it's not a jurisdictional requirement that it be filed before the judge that handled it.
There are options. There are options that the party bringing either the petition or starting a plenary action has, and I selected the option that I thought made sense to me to have everything all in one place to deal with all at one time.
And that's not totally novel, is it?
No.
I mean, there's been many times in the past where one judge is assigned over this kind of, and I could think of some examples, but I will keep them to myself.
I agree. I have had over my years of experience, sometimes it's an action, as I said, sometimes it's a motion, sometimes it's a notice of petition and petition, sometimes with the same judge, the underlying judge, sometimes not. But again, if we go back to the RJI and the complaint about the RJI, we get into an abuse of discretion standard here as well. Because the case law that I provided, and there aren't a lot dealing with an RJI, admittedly, when I did look, the Mortis versus Wilk case clearly stated that it was an abuse of discretion standard. And here, Justice Panepino, that's the lens that should be, that her decision should be looked at. And there's been no proof that she abused her discretion in determining that these were related cases and that they should stay with her. With that being the standard, this court should affirm that decision and keep the case with Justice Panepino. I would also point out on the issue of the RJI itself, it does say I asked for a preliminary conference. That's what it does say. But it also indicates there's a question on there. Has a summons and complaint been served? I answered truthfully, no. The clerk's office still accepted this. There are so many, I've had RJIs over the years rejected by the clerk's office for whatever reason. They could have, with this information, at the record at page 39 and 40, rejected the RJI. So the chief's clerk's office didn't reject it.
Well, counsel, why? What would be the purpose of filing an RJI just days after you file the summons and complaint, seeking a preliminary conference?
To get a schedule?
Just a minute.
Okay.
Before you serve that complaint, other than get a judge assigned.
To get a scheduling order.
How could you get a scheduling order before you serve the pleading?
Because it was out for service. I knew who the attorney was. They're going to be
See, that's the
appearing.
point. That's the point that's in front of us. They say, their argument is, you filed that RJI days after the complaint was filed so that you could make sure that you got this action in front of Justice Panepinto. They couldn't have scheduled a preliminary conference because it hadn't even been served.
But I knew based on my experience that it would take about a month to 2 months to get that preliminary conference. This was perhaps overzealousness on my part to want to move this along and get a conference, but we didn't, by the time it was served, I think the notice for the conference came in after that, because there is the inevitable delay. You file this RJI, it percolates for a bit, and then eventually you get your notice for a pretrial. And by that time, it had been served. No harm, no foul. But had I waited, Your Honor, had I waited until after service and then filed this RJI, we'd still be here today with every other complaint that he has about the way that I did this. So really, we're still in the same position.
Well, but if you had if you had waited and served it, they might have filed an RJI and it would have looked very different.
Maybe.
It would have looked very different.
Maybe they would have, but maybe they wouldn't.
And that's what's in front of us right now is what is the remedy to this question of whether or not this complaint should or should not have been dismissed?
Well, it shouldn't be, because again, it allows for the conversion, which has now happened. And on top of it, he has not sought the remedy of sending this back to the other judges that heard it before. So that's not even before this panel, I would suggest. And other than that, I'll just rely on the remainder of my brief.
Thank you, counsel.